Join us on video. Thank you. Good morning. The Court of Appeals is now in session.
Kate, you're muted.
So many buttons, so little time. At any rate, good morning and welcome to the Utah Court of Appeals. I'm Senior Judge Kate Appleby. With me this morning are Judges Harris and Orem. We're beginning with N. Ray AG, and I will invite counsel to state their appearances. Everybody knows the drill at this point, so I won't review the rules.
Julie Nelson for Appellant Mother, and while I'm stating my appearance, I wanted to save 4 minutes for rebuttal.
Thank you.
Martha Pierce, Attorney Guardian Ad Litem for the minor children.
And John Peterson, Assistant Attorney General for the state of Utah.
Thank you, counsel. Ms. Nelson.
Thank you, Your Honor. I'd like to start in the record. I'd like to start with the colloquy that happened between Mother and her lawyer while she was allegedly relinquishing her parental rights. So I'm starting in the record on page 230. Trial counsel says to Mother, "You and I have discussed the petition that you're intending to sign today, and we've had the chance to talk about it, correct?" Mother says yes. Then there's some more questions. On page 231, trial counsel says, "So, Shelley, you and I have had the opportunity to talk about the petition, and you're ready to proceed, correct?" Mother says yes. On 232, trial counsel says, "Okay, and you understand that this is irrevocable and can't be changed upon signature, correct?" Mother says yes. And trial counsel says, "You understand that when the judge accepts it, that your parental rights will be terminated, correct?" Now, I think it's pretty clear that up until this point, Mother and her counsel are talking about a written document, a petition that Mother will sign. No one objected. No one interjected to say, "Oh, you know what, she actually doesn't have to sign it. She can just do it in court here." They're talking about a document that she's going to sign. And then on 233, at that point, the court takes over the conversation, and they have the conversation about whether there will be an open adoption. And at the end of that conversation, the court says, "And you're still willing to proceed today?" And the mother says, "Yeah." "Yeah, what?" "Yeah, I'm still willing to proceed today." That's it. That's the last thing she says. Poof. At that moment, her parental rights have been terminated because just a few lines later, the court says, "I will accept the mother's voluntary relinquishment." But I think that it's clear that Mother thought she was supposed to sign a document. And when they asked her if she was going to proceed, all she was proceeding with was the proceeding, not poof, I'm now relinquishing my parental rights. And Judge Appleby.
Why is the signature not a sort of belt and suspenders approach to a termination?
Well, for one thing, I'm not familiar with any other area of the law where a signature is just a technicality. There are numerous situations where the signature is the defining moment. And I think from that colloquy that we just saw, the conversation assumed that the signature was the defining moment. And I think that leads us right into the plain language of the statute. So we're looking at section 80-4-307. And I understand that subsection 1 is not a paragon of clarity. It says it can sign or confirm. But section...
has a question.
Oh, sorry.
Did you have one, Judge Appleby? Oh, okay.
No, I was just trying to give you some space.
I just want to, okay, so section 1 it says sign or confirm.
Right.
And based on your discussion of the record, the colloquy, it appears, based on what you're arguing, that the parties had more or less, I think what you're saying is the parties had elected sign. Assuming there's more than one option, they had elected sign because they're, as you say, they're I guess, contemplating that she's going to sign something. But what do we do with this language in the statute that seems to contemplate a different path?
Well, I think we turn to sections 3 and sections 4 and see that those both require signature. So I think that if we're talking about confirm, now I agree with you that it sounds like they had elected sign and everybody seemed to be on board with that up until the critical moment. But even if subsection 1 suggests that there's a proceeding where you might confirm, subsections 3 and 4 clearly contemplate some kind of signature, which to me sounds like a two-step process if you're going to confirm. That's fine, you can go ahead and confirm, but you also have to sign. And frankly, we see this, lots of times in the law where, yeah, we're going to have a conversation about it. That's fine, like maybe a contract. We're going to have a conversation about it. We're going to agree to it, but we're not going to actually execute it until it's signed. And 3 and 4 don't say anything about confirming. They only talk about signing. 3 talks about reading and signing, which is clearly a written document twice in one sentence. And subsection 4 says it's effective when the voluntary relinquishment or consent is signed and may not be revoked. Now, in the opposing briefs, they've argued that that's the judge's signature. I don't see why we need a statute to say that something's effective when the judge signs it. Of course that's true. That's always true. That's, in my view, the most superfluous interpretation of a statutory subsection you could have, because that's always true. We don't need that in there. Instead, we should be reading the statute to give it meaning. Judge Harris?
Yeah, I was intrigued with something a little nugget of information you gave us in your gray brief about statutory history. The fact that there are 2 statutes that talk about this, one in the Adoption Act and one here that we're talking about in this case, in the child welfare statutes. And in the year 2000, the legislature went in and took out the or confirm language and made very clear in the adoption statute that there needed to be a signature. They didn't at the same time make the same or similar changes to the child welfare statute. What should we read into that, and why shouldn't we read that against your position? Namely, why shouldn't we sort of say, well, the legislature must have made a purposeful decision to amend one statute and not the other? What's your response to that?
Well, my response to that is I think it's an oversight, and I think we can see that it's an oversight from sections 3 and 4 that require a signature, and certainly the policies that were discussed in the Adoption Act apply at least as strongly in this context. We have case after case talking about how important due process is in the termination of parental rights, how these are the most precious rights that anybody has. This is one of the most grave things that anybody can do, to give them up or have them terminated. And we are happily seeing a slew of cases making sure that due process is given to parents in this situation when their rights are being terminated through a termination trial. I don't see any reason why we would hold a lower standard here. Now, I understand your point that, well, maybe it was an intentional decision not to remove the language confirm, but I just don't see that from 3 or 4 or from what actually happened in court this day or from the policies that underlie what's going on here. I wasn't sure if Judge Appleby had a question.
Well, what I was thinking about is what about an instance in which somebody agrees on the record as happened in this case, and it's a virtual proceeding, and the person signs the document, everything goes off the record, and then the person rips up the document.
They sign the document and then they rip it up. Well,
Yeah. So it never makes it to court, and so there's no signature that the court can see. Then what?
Well, I think then we look at the same sorts of rules that we would have where, somebody signs a contract and then they rip it up. Does that make it effective? Well, to be honest, I'm not sure, but we have the judge here has to accept it. So I think what we see here is that the judge has to
accept it. Do you mean it has to be received by the court? I guess that's part of my question.
I think so. Yes.
So in this virtual universe we're in, nothing is effective until it gets filed.
Sure, just like everything else. Yes, but that doesn't give me any heartburn because so many things are not effective until they're actually filed with the court, right? So I see that as being the same.
Thanks. Judge Orem has a question, I think.
Well, I don't have a question. I was just going to say, I think the analogy to the contract might be informative. If you are given a contract, you sign it, you tear it up, throw it in the garbage can, that's a nullity. You sign it deliver it, now you got something. I mean, deeds and contracts and other written documents that are purportedly effective upon signing really are not effective until signed and delivered. If you have second thoughts and in the privacy of your own office, having signed it, tear it up and nothing comes of it, it's a nullity. So
That's exactly right. I mean, I think of, an insurance contract. You've discussed with your insurance agent numerous times that you're going to do this. He sends you the paperwork. You sign it or you don't sign it, but you never send it back. I don't think you have an insurance policy in that context. And like I said, filing anything is what makes it operative in the court system. So that just doesn't give me any heartburn. Judge Harris?
We have a statute here that tells us what makes it operative. It isn't the filing, it's the signing. It's subsection 4 that you're dependent on. Voluntary relinquishment is effective when it is signed. And so under your scenario, if we're on a virtual proceeding, and the judge goes through a colloquy and does the certification in paragraph 3 that this is all being done knowingly and voluntarily, and then the person signs it on the video screen, and the judge sees that, and we have a record of that, I think there'd be a pretty good argument that, notwithstanding that 10 minutes later it gets ripped up and thrown in the trash, we still have an effective relinquishment, given that it's supposed to be effective when signed. What's your response to that?
No, I agree with that completely, but it's a slightly different hypothetical than Judge Appleby's, because in your scenario, the judge watched the signature, and my understanding of Judge Appleby's was that it was set up like this, where we go off of court and then the person is signing it in their lawyer's office. And so in those two scenarios, in your scenario, the judge has seen it. I think they've accepted it, but in the other, maybe not.
Well, maybe I don't know how these are happening nowadays. Every relinquishment that ever happened in front of me down on the 3rd floor, there was the signature happened in front of me.
Right.
That was the way people did it.
Right.
6 years ago. They came into court and there was a document that would be passed around and the parent would sign it and the judge would ask some questions and then the judge would countersign it because the judge has to do a certification. The judge is under both the adoption and this statute. The judge is included in the universe of people that have to certify. It isn't
Right.
enough for the judge to just observe the signing. The judge actually has to certify. And I got into a habit of sort of adding language to the documents that were put in front of me to make sure that it was plain that I was doing this certification. But it all happened right in front of the court. And the court would see the signature and then make a determination that the signature was being put onto the document knowingly and voluntarily and without any duress and all of that. And so if that happens in front of the court, I think we've got a valid relinquishment, even though something gets thrown away 10 minutes later. I think we're in agreement on that, it sounds like.
100%. 100%. And I think that the issue is, what do we do in WebEx? Well, we can have due process on WebEx too. It's fine, right? Now, the scenario you described where the person signs it right there on WebEx, great. Best practice, right? Or the judge could say, now, ma'am, do I have your permission right now to sign on your behalf? This is as if you were signing away your parental rights. Right now, can I do this? But that's not what happened here. What happened here was he said, do you wish to proceed? And she said, yeah. And that was it. That doesn't sound, that's just not the same as a signature. And it's not a technicality. It's just that the process wasn't completed. And when it came time for her to actually sign it, she didn't want to. And, parents have that right. They can choose not to sign it at the moment, and the state can decide that they want to go forward with the termination trial.
So let me follow up on one more thing. I know your time is up, but just to make sure I have your position in mind about what we do with this language that says or confirm. I think you said, well, in response to my previous question, that you envisioned this as a two-step process, as the judge is going to sort of confirm some things before signature. But the judge has to do that anyway under Section 3. So if the words or confirm weren't in the statute, there would still need to be this sort of two-step process that you're describing, right?
Right.
So what do the words or confirm do here? And is the other side correct that your statutory interpretation is effectively reading those two words out of the statute?
I think it's not an unfair criticism to say that my interpretation reads those two words out, but my response is, first, their interpretation reads out subsections 3 and subsections 4 altogether. So given the choice between reading out two words or two subsections, I think we have to read out two words as just not being operative. Or we could say, all right, that's fine. You can confirm. Remember that you don't have to confirm, except in juvenile court. In district court, you don't have to do this confirmation process in front of the judge. You can confirm it, under these other, under a public officer appointed by the court for the purpose of taking consents or relinquishments. But even so, you have to sign it, and the judge has to work through all of the questions, just like you've just described. The judge has to make sure the person isn't under duress. They're not doing it for the purposes of getting out of child support. They are doing it in the best interest of the child, all those other things. And there has to be a signature.
All right, one more question with beg the indulgence of my fellow panelists. It's
sure
on
they will.
brand. I'm going over time. I'm sorry. Okay, so what you're saying is we have a situation where your statutory interpretation is requiring us to read two words out of the statute, and your response to that is, well, their statutory interpretation requires us to read out sort of the essence of these other two complete subsections that clearly involve a signature. Okay, I get that. What do we do then? When we have competing statutory interpretations, and let's say we agree with you hypothetically, let's just assume for the purposes of the question that we agree with your premise that both statutory interpretations in front of us here require us to read something out of the statute. How do we break that tie? What are the rules of statutory interpretation that allow us to decide between competing interpretations, each of which requires us to read something out of the statute?
Well, first, I think there is a way to say, well, confirm means something if you're not in front of a judge. Fine. But if it doesn't, then we look for global statutory interpretation rules. We look for the thing that makes things the most harmonious, right? We give meaning to everything that we can. We look for something that is consistent with what the legislature intends. We look for something that is not absurd. And we look to make a comprehensive system here. And I think that all of those things point towards needing a signature. And frankly, I think that what happened in this particular case tells us exactly why. Because if we go back and we look at the beginning of the statutes about termination of parental rights or relinquishment, and we talk about how important it is to make sure that parents are doing this, of their free will, we recognize how important it is for parents to have that relationship. All of those things point towards making sure that parents truly understand what they're doing when they're doing it. And the way to confirm that is through a signature. So I think that our normal rules of statutory interpretation, asking for a harmonious interpretation, get us over the finish line. Thank you.
Thank you, Ms. Nelson. No other questions, judges? All right, let's turn now to Ms. Pierce. It appears that you're splitting time with Mr. Peterson. Is that correct?
That's correct.
All right.
May it please Martha Pierce, attorney guarding the ad litem for the minor children. I want to direct this court's attention to subsections 4 and 5. Subsection 4 says that all those provisions in 84104 don't apply to voluntary relinquishment. So this is a different scenario. Subsection 5 says, subsection 4 says it's final when signed and may not be revoked. I think counsel's big mistake is she's saying, well, it's not final if it's not signed. And I think we need to make a distinction between contract law and pleading law, because it was my brief that explained the history of relinquishments in adoption courts versus termination versus juvenile courts. And adoption courts are unique because you can bring a document to the court and say, look, I obtained mother's signature. Mother has relinquished. That happens all the time in adoption courts. So when the parent executes that contract, and I think we can look at contract law there, when the parent executes that contract, someone can take it to court and say, look, I obtained mother's signature. You can't do that in juvenile court. You have to have live testimony. So let's think of the example where, let's say a caseworker prepared a petition, signed the petition, asked for relief, and the attorney signed it. For some reason, the caseworker forgot to verify it. Caseworker goes to court, swears an oath, puts on live testimony. She's subject to direct cross-examination, clarifying questions by the judge. The judge makes credibility findings and gives the caseworker the relief that she asked for. The next day, can she say, look, I forgot to verify my underlying petition. Therefore, you have to throw out the window all of my live testimony, your credibility findings, all of that. No, she couldn't do that. There's no scenario where you'd let somebody do that because we believe, because the judge took that testimony, the judge took it very seriously. And I think that's the case here. There's no question. That makes me very nervous. But I think you have to look at this case like I put in my brief that we've always done what we said a belt and suspenders approach, where you have to put on the live testimony and then you have to sign it. But I don't think that not having a signature undermines it. Otherwise, the statute would have said lack of signature undermines this. It doesn't say that. It says you have to confirm under oath. Mother confirmed under oath that court took her testimony. Are there questions?
Don't sections 3 and 4 more or less, they certainly seem to envision, so maybe the word requires a little too much, but well, let me just start there. Don't sections 3 and 4 clearly appear to envision the parent signing a document that indicates that they're intending to relinquish?
You know, and I think that's a holdover from the adoption statute, where you can just bring in a document. Someone from the adoption agency can bring in a document and say, I obtained mother's signature, and mother doesn't even have to appear in court. So I think the first part of this, you have to shall sign it or confirm under oath. I think that's relevant to the juvenile court procedure, where the juvenile court is taking live testimony.
Well, I'm asking about subsection 3, not subsection 1.
I know you are. That is contemplating the option where someone can provide consent out of court. But then the whole statute also, that used to be allowed. And then this whole statute just provides for that option, as I said in my brief. It provides for the option of somebody taking a consent out of court, and then it takes away that option. So I think we have to look at it in the history of this provision and in the history of splitting the jurisdiction out between the adoption court and the termination court. And the termination court actually provides more process to the parent, because it says, we're not going to allow for off-site relinquishments. You have to come into court. I have to look at you. You have to swear under oath. I have to take your testimony. I have to see that this is going to be voluntary. So I think there's nothing in the statute that says lack of the signature undermines that whole effort by the judge to take live testimony and to take the confirmation under oath, which the court did.
Well, what's the court supposed to certify to in a confirm? Let's assume that you're right, that there's sign or confirm. There's alternative pathways here that they can do it through signature, or they can do it through confirmation in court under oath. But in subsection 3, there doesn't seem to be any instructions for the court about what to certify in that situation. In other words, the statute doesn't say the court shall certify that the individual either executing the consent or confirming in open court has done this and that or the other. It says the court shall certify that the individual executing the consent understands it and has signed it freely and voluntarily. That's a pretty clear indication that there's supposed to be something that's signed, right?
It's a pretty clear indication that that is one avenue to get a consent. But again, as I said in my brief, it seems pretty odd for a trial judge to make an affirmation by information and belief, and then to make a set of findings by clear and convincing evidence. So I think this applies to the first path of obtaining, because it says the court appointed officer or other authorized person. So I think they're talking about that off-site obtaining of a consent.
Well, if they were talking about off-site, they wouldn't include the court there, would they? They would say an appointed officer or other authorized person outside of court who's taking the signature shall certify, etc. But the court is explicitly included there, that the court needs to be also one of the individuals or entities that's making this certification, right?
Right. I could see a court co-signing something like that. I could see that happening. And I would have to check the adoption statute to see if that's an available path. Judge Appleby?
But if the court signature is required, does that mean that the relinquishment is not effective until the court receives the document and signs it?
Well, I think that's what makes any judgment final, is when a court signs it and then enters it on the record.
So for some number of days, it's not done.
So,
Then someone could file a notice to submit and make it happen. But I think that's the case in all. I think that's how the courts finalize their orders in all cases.
well,
And then they enter in the record.
can I go back to your previous point about I can tell you that the adoption statute does have this same certification statute in it. Because that's the only way I, as a district judge, would have ever come face to face with this scenario. And in that scenario, there's still a requirement, even though signature is the only thing that can happen in the adoption scenario now, there's still a requirement that the court make a similar sort of certification like this. And so I don't know what to make of that, but
I think the mistake again is this says it's effective when signed and may not be revoked. But I don't think that means it's not effective if you don't have a parent signing something. I don't think the statute provides that if a parent withholds their signature, they can undermine that whole testimony given under oath.
Right, but that still leaves the case kind of in limbo for some period of time, because if it's not effective until the court signs it, then it's not effective. And I guess part of what I'm hung up with here is that, like Judge Harris, I used to do a lot of these when I was a trial court judge, but it would all be done right at the same time in the same room. And I could see what was being signed and I countersigned it. So it's all done. But the scenario you're advocating is the parent does or doesn't sign it. It's effective from the parent's perspective, but it's not legally effective until the judge gets it and signs it.
But in your situation as a district court judge, it has to be a done deal, because then you proceed to the adoption. And in juvenile matters, the adoption is a totally different entity with a totally different number, totally different pleadings. So there is a lag in between the relinquishment and the adoption.
and just to be clear, your position about subsection 4, I guess I'm not sure. Is your position that the signature discussed in subsection 4 is the parents?
It is vague, and I think I argued that it's the judges, but I think you could read into it that they're talking about the off-site consent, or in your case, the in-court consent that takes place as a prelude to adoption. But I think that's not the only road to get a relinquishment. And in the juvenile context, the parent gets extra process because it's a live proceeding under oath. And I don't know how common it is nowadays for there to be off-site consents and relinquishments in the adoption context. I know that used to be a very common practice, but we still have litigation. I mean, there was a Supreme Court case 2 years ago involving an off-site consent where the father challenged it. But that's not the case in juvenile court. It has to be live testimony. And I think this case is about respecting that live testimony and the judge's ability to judge the credibility, the demeanor, all of that, and to make findings. And if we require this, then we're not respecting that judicial process.
Well, it's also about respecting the legislative command. If we read the statute as requiring a parent's signature, then that's the way it is, right? We've got to respect that first and foremost, don't we?
Well, I think the only place where it says shall sign is under 1, and it says shall sign or confirm. There's no place else here where it says shall sign. It just says it's effective when signed. So that's talking about the consent. But the shall language is in subsection 1, and it says shall sign or confirm. So the legislature clearly is giving the juvenile courts power to allow.
If the signature in subsection 4 is the parents,
Right.
then it says the relinquishment is effective when signed.
Right.
And your position is, well, that doesn't necessarily mean it's ineffective if not signed. Is that what you're saying to us?
I think this is referring to an off-site confirmation, where in between the time somebody obtains the mother's signature and they go to the district court, the mom says, wait a minute, I've changed my mind. The adoptive couple can say, no, you signed it. We get to take this to the court. I think that's what that's referring to. I don't think
that can't be anymore, though, as you point out. I mean, in juvenile court, it all has to happen in court now when the child under subsection 2, if the child is in the system, it has to happen in front of the judge. So that's a vestige in your view? That's a whole subsection that doesn't apply ever anymore?
Well, there's a lot of things here that don't apply anymore. Like several times it says the appointed officer, authorized person allowed to take consent. That doesn't apply. I mean, we still have all these vestiges of when you could take an off-site consent. And nowadays, there's no such thing as an appointed officer or authorized person taking a consent in juvenile court. You have to go to court. So you have to look at this and I provide the history in my brief about how that works.
So you agree with Ms. Nelson that no matter which way we come out on this, we're going to have to be effectively reading something out of the statute?
Well, I think the statute reads it out for you because it provides all these other methods. It provides for an authorized person to take consent, but then it takes it away with the other hand saying, well, only a juvenile court can take consent or can affirm under oath.
Of certain children?
Well, yeah, of the children over which the court already has jurisdiction. So again, the parent gets even more process because the parent is doing the consent in front of a court who's very familiar with the facts of this case. So I think there's way more due process built into the juvenile court relinquishment procedure than there is in the adoption procedure. And with that, I'll cede my time to my colleague. Thank you.
Thank you, Ms. Pierce. Let's hear from Mr. Peterson.
May it please the court, John Peterson on behalf of the state of Utah. It seems like across the board, everybody realizes that there are some problems with this statute. Clearly, there's the intersection of the old world and the new world. And the old world was definitely a world where there's ruled by the wet signature. And there's also an intersection between the General Adoption Act and the specifics regarding the juvenile court. I mean, for a normal adoption, yeah, you could be in Wisconsin and you could have a person who's authorized to take your consent, and you would sign, the relinquishment, and then that would get transported to a court here to be eventually entered. But I think the similarity in both cases is that, the document itself, even if once you sign the relinquishment document, it's not self-effectuating. It does have to go before a judge, either in the district court or the juvenile court, to be validated. And I think it's really what's important to look at is what the statute is looking to is to ensure that the person is knowingly and voluntarily relinquishing their rights. And, as counsel for the mother conceded, if counsel had simply said to mother, hey, do you mind if I sign this for you? And she said, yeah, then we wouldn't be here. That would be a done deal. And so it seems to me that we're really elevating the fact of the mere moving the pen across the paper to a much more important position in this statute than the statute really suggests.
I gotta push back there a little bit, Mr. Peterson. There's so many areas of the law where pushing the pen across the paper is a really important step, right? That's the way our law has been oriented since the Blackstonian days. So, we shouldn't get too far down the road of poo-pooing the value of a wet signature. There is value in the finality of putting pen to paper and, dotting the I and crossing the T and putting the pen down and feeling that you've done something, right?
But I would push back also saying, note that, the Digital Signature Act and those kinds of things are really moving towards a world without that. I know for a fact I haven't put pen to paper and signed anything for months. It just doesn't happen anymore.
Well, let me modify it then. Even a virtual signature, you type your name in with the S/S and you do it, or if you're closing on a house, you actually put a pen in a box and say, this is my signature, and then it virtually applies the rest of the time. There's still some value in having a signature on a page, on a piece of paper. Whether that signature is virtual or not, it really is beside the point. Your argument here is basically that there doesn't have to be a signature of any kind, right?
Yeah. As we discussed, under subsection 1, there is the language sign or confirm. And if signing is the absolute sine qua non, then the or confirm becomes complete surplusage in this situation. And that, it doesn't mean much. It doesn't really mean anything.
Well, I think the other side has conceded that if we adopt their position, we are rendering or confirm surplusage. But their response is, okay, but if we adopt your position, there's going to be a fair bit of surplusage in the statute. And I think Ms. Pierce more or less conceded that. So we have a situation where we're going to have to read something out of the statute. Help me understand why we should read sections 3 and 4 out of the statute instead of or confirm out of the statute.
I mean, I think this case is a little bit unique, and also in that this is a COVID era case, and so everything was a little bit different and more sort of wonky when we're doing. I mean, the transition to remote hearings has not been seamless, to say the least. And I mean, I'm not saying that you can ignore a statute because COVID, but I think it changed things. I mean, and the anticipation in this case was that she was just, I mean, going to put pen to paper and it's going to be filed, but it never quite happened. But I mean, it's also important to note this matter was set to be live, and Mother asked for it to be remote, and then Mother asked for a second hearing that she didn't show up for. I mean, so arguably some of these issues aren't even really properly before this court. Her attorney came forward in the second hearing, but she wasn't even there to argue what her position was about her signature and understanding. I mean, I don't have a perfect answer really to how to inform the statute, other than I think looking at what is the essence of the statute, and the essence is really determining that a person is doing what they're doing knowingly and voluntarily. And it does, I mean, and the way we've done that historically has been by the wet signature, but we're moving forward. I mean, and there has been some reformation. I don't know if that's completely satisfactory. I mean, I don't have an answer exactly to how to, I mean, clearly, some language has to be either read out or sort of translated through the lens of progress. But I think it really is important. I think that really the idea that the voluntary is effective when signed. I really think that does have to be signed by the court, because you're walking around with a signed relinquishment papers, and those are not effective. They simply just can't be.
So,
Well, so then that's back to my issue that I tried to explore earlier. So does that leave the relinquishment just in limbo until the court signs it?
I would argue, I mean, that it does. I mean, the court's, or I accept it is not. I mean, it's really the court signing the document, and that is what terminates parental rights and makes the
So it's
entire.
not effective when it's in the mail or, in the queue and just hasn't been signed.
I would argue it's not. I mean, really, until the court has fixed its imprimatur to the document, there is no relinquishment and termination of parental right. There's the intent to relinquish, and that has been done, but it is only the juvenile court that can actually terminate the parental rights, which is sort of the ultimate.
Isn't that a little odd?
I mean, everything really falls down to a court order. I mean, if you have a termination of parental rights trial.
Well, sure, but for example, in this scenario, I think adoption could proceed, but maybe an adoption is proceeding before the relinquishment is finalized by the court. So is the adoption not legitimate because the court hasn't signed it? Go ahead, Judge Harrison.
yeah, I'm struggling with this whole notion that subsection 4 could be referring to the court signature rather than the parent. My first problem with that is when I read sections 3 and 4 together. Section 3 clearly, there's no question, I don't even think you're arguing, that subsection 3, when we're talking about signing the consent or relinquishment, we're talking about the parent signing the consent or relinquishment, because the court is the one supposed to certify that the signature on the consent or relinquishment has been rendered there freely and voluntarily and without duress. And so clearly subsection 3 is envisioning that the person signing the consent or relinquishment is not the court, because the court's going to do this separate certification. The person signing the consent or relinquishment is the parent. And then right after that, in subsection 4, it is phrased in the passive voice, effective when signed, but it's hard for me not to read those two subsections together as clearly indicating that the person who's signing the relinquishment is not the court, it's the parent. And the second, well, respond to that, and then I have a second point.
I mean, I guess I would respond that I think I agree with Ms. Pierce that really subsection 3 seems to be very kind of a vestigial remainder of the adoption kind of a situation where you can have a person authorized or public official taking. And that really refers to the process of, if you're having a consent taken out of state by an authorized person, obviously they're not just going to send a quick email say, yeah, they came in here and I confirmed that they said it's okay. It's going to be a signed document. That's the way that process works. But there is an alternate path in the juvenile court and it's required really that you have to appear in front of the court. Do people generally bring the papers in and hand to the court? Yes, but I'd argue that that's not really the essence of the proceeding here. Is the juvenile court actually doing the assuring that there is a knowing and voluntary relinquishment, and also making the best interest findings required. I mean, and so I really think that subsection 3 is somewhat vestigial, and if you're going to read out that part as being applicable to a different scenario.
Let's assume that we read it out as vestigial, but doesn't the way subsection 3 is phrased, even if vestigial, inform the way we should interpret subsection 4?
I think it informs it, but I think the important part is the knowingly and understandingly, and the freely and voluntarily, not so much the did you actually scribble on it or not. Not, I mean, not to make light of this signature, but that's the point. The point is knowingly and voluntarily. Those are the primary issues before the court, and those can be determined orally on the record, probably more effectively than here's something that she signed and I know she understood it.
Okay, and then my second issue with this subsection 4 being the court signature and not the parents, my second issue with that argument is that the paperwork, at least when I was at the trial court level, it wasn't always submitted to me in the same forms. Like different lawyers did this differently. And the thing that the court signed was the certification that everything's done knowingly and voluntarily. And then ultimately the court signs an order of termination. But there were times where the relinquishment itself was a separate document that the court didn't have to countersign. There was a separate certification and then a separate order of termination. I mean, you could, and I did on occasion, tie this all up neatly with a bow without the court ever signing or countersigning the actual relinquishment itself, which tells me that subsection 4 probably also doesn't refer to the court's signature on the relinquishment, because these things can be done without the court's signature on the relinquishment. I mean, subsection 4 doesn't talk about the order of termination, it's talking about the relinquishment. So, and again, sometimes the paperwork would be submitted where the court would countersign a certification right on the document, but I don't think that's required. So if the court can complete this without actually signing the relinquishment in any form, how can subsection 4 be referring to the court signature instead of to the parents?
I guess I just responded that really, I mean, the only interpretation I think that really makes subsection 1, the sign or confirm language, mean anything, but it's not clear. I mean, it's not a good statute in some respects. I do say I have used up my time. I'm happy to answer more questions, but I have.
Thank you for answering my questions over time, Mr. Peterson. Thank you.
Thank you. Ms. Nelson?
I'm here. Thanks. I have just a few responses. To Ms. Pierce's comparison of the caseworker saying, I forgot, I think that's actually important, because I forgot is different than I have changed my mind. I am not going to sign these papers because I do not want to relinquish my rights to my children. The caseworker presumably could say, oh, I forgot to do it yesterday, but I'm happy to do it now. And had mother done that here, we wouldn't be here. But that's not what happened. She did not want to sign those papers. And the entire conversation is predicated on her thinking that she is going to be signing some papers. That's why I started with the record. It's very clear. She thought she was going to be signing. And when it came right down to it, she couldn't do it. She wouldn't do it. And that's why that signature exists. Now, all of this normally certainly would be better if it happened all at the same hearing. But as Judge Harris has correctly pointed out, we're talking about the relinquishment becoming effective, not the actual order of termination becoming effective. Once the parent has signed the relinquishment, it's effective as to the parent. The parent can't back out of it, but the court can still back out of it. The court can still reject it on the basis that, actually, I changed my mind. I think you're doing this to get out of child support, or I don't think this is for best interests. The court's order is effective. The order is effective when the court signs it, but the relinquishment is effective when the parent signs it. It just doesn't make sense any other way. Now, as to whether Section 3 is a vestige of the Adoption Act, I mean, obviously my response again is, well, get rid of the words or confirm, and then we don't have this problem. But I guess more to the point, we've talked a lot about what happens in juvenile court, but terminations don't only happen in juvenile court, they also happen in district court. And subsection 2 which has gotten almost no attention, tells us that only a juvenile court can take the consents or relinquishments. But subsection 1 refers to other situations as well, district court situations. That's where the or confirm language might have some impact. You're going to confirm this, maybe in Wisconsin, but you're still going to have to sign it, right? And as Mr. Peterson said, you're still going to send those papers in. So I guess my position is that the reading out, if we need to read out or confirm, then let's do that. That's the one that does the least violence to the statute as a whole. They're talking about breaking off huge sections of the statute, and that argument simply doesn't make sense. If there are no further questions, I will conclude. We ask you to reverse.
It appears that there are no further questions, so I'm going to ask Mr. Peterson and Ms. Pierce to turn on the cameras. We will take this matter under advisement, but we thank you for your participation today. It's an interesting issue, and we will get a decision as soon as we can. But in the meantime, I wish you well, and thank you again.
Thank you, Your Honor.